you know that suspects within the precinct of a police station have rights? They have fundamental rights. But what gives the police the right? Before we move on to this right, let's look at what gives the police force or security agencies this right to arrest, to detect, to detain, to apprehend criminals, and to generally enforce laws within the Federation. Well, Section 4 of the Nigerian Police Act, passed as far back as 2020, gives the police force these powers. If you also look at Section 14 of the 1999 Constitution as amended, it says that the primary responsibility of government shall be their welfare and security. So the security aspect is what security agencies are mandated to, take care of. So now back to the right of a suspect within the precinct of the police custody. Let's also understand that fundamentally, suspects are not convicts. Suspects are mere suspects or witness, meaning that they are presumed innocent. The presumption of innocence inures in their favor. They are presumed innocent until proven guilty by a court of competent jurisdiction. Therefore, these suspects also have rights. Number 1, Section 35 sub 2 of the 1999 Constitution provides that anyone who is arrested for any offense shall have the right to remain silent. That's number 1 right of a suspect, the right to silence, to remain silent until after consultation with a legal practitioner or any other person of his choice. That is the second right. Fundamentally, you have a right, the suspect has a right to remain silent. Secondly, a right to consult with a legal practitioner or any other person of his choice. Can I tell you something? Section 17 sub 2 of the Administration of Criminal Justice Act provides that the suspect, if the suspect cannot find a legal practitioner, can also consult with an officer of the Legal Aid Council of Nigeria, or consult with a justice of the peace, or consult with any member of a civil society organization or any other person of the suspect choice. So it could be a spouse, it could be a friend, it could be a relative, or just any person of the suspect choice. That is within the purview or the decision of the suspect. Now, the other right of a suspect who has been arrested and is within the custody of the police. The suspect, before writing a statement, before taking down, the police force taking down the statement of the suspect also has, apart from the right to remain silent and the right to consultation with legal practitioner, also has the right to be informed in writing within 24 hours the reason for the arrest and detention. And that you will see in Section 35 sub 3 of the 1999 Constitution. So 24 hours, number 1, the reason for the arrest and detention, and in the language that the suspect understand. That's also fundamental. And then let's look at the other right of the suspect who is within the precinct of the police station. Before even taking a statement, the suspect has a right to an interpreter. That is very fundamental, and this interpretation or this interpreter is at no cost to the suspect. The suspect is not expected to pay for this interpreter, and this is usually when the suspect cannot understand English. That suspect has a right to an interpreter, and that you find in Section 17 sub 3 of the Administration of Criminal Justice Act. And then Section 34 sub 1 of the Administration of Criminal Justice Act also provides that the suspect has a right to be free from any form of degrading treatment or any inhumane treatment, such as torture, such as beating to extract, evidence. All these have been prohibited by virtue of the Administration of Criminal Justice Act passed in 2015, as well as the 1999 Constitution. Section 34 sub 1 provides that or guarantees the right to dignity of human person, and therefore any form of degrading or inhumane treatment such as torture is prohibited by virtue of that particular section. And then handcuffs, chain cuffs, leg cuffs, whatever cuffs have also been abolished. The suspect is not expected to be put under such circumstance. However, there could be an exception to this where there is a fear that the suspect might escape, or there's a fear for the suspect's own safety. Yes, that could be allowed to restrain the suspect for the safety of the suspect, or for fear that the suspect might escape. This could be perhaps some exception to that particular provision. Well, see you next time.